Very good afternoon to all. Myself is K.Bakiyaraj, working as Assistant Professor in the Department of MBA at Dr. Residence College of Arts and Science. So last previous class what we discussed, we had discussed about the companies that 2013, and the company 2013 we were discussed about the topic about introduction to the term of the company and the company law and the prospectus. On this part we are going to discuss about the process of filling the issue of prospectus under the company law and what are the content to be needed to be process for filling the prospectus. The content number 1 about the name and other crucial information such as the registered office, registered address of office secretary and the auditors, etc. Process number 2, the date of issue including the opening date and the closing date. Content number 3, undertaking of the board of directors regarding separate bank accounts for the purpose of keeping receipt of the issues. Content number 4 is the consent of the directors, the auditors, and the bankers to the issue and the expert opinion. Content number 5, the detail of the resolution passed for the issues, and this is content number 5. Content number 6, procedures and time schedule for the allotment of the securities. Content number 7, the capital structures of the company of the object of the issue. Content number 9, the objective of the business and its locations. And content number 10, particulars related to the risk factors to the specific projects. Content number 11, the amount is payable on the premium. Content number 12, detail of the directors, their remuneration and the extent of the interest of the company. And content number 13, report of the financial information such as the auditors report of profit and loss of the 5 financial years, business and transaction reports, statement of the compliance with the provision of the act and any other reports. So these are the some few content to be defined, prescribed by the process of filling the issue of prospectus under the company's law. And this part we are going to discuss about the allotment of securities. What do you mean by the securities and how we are the company's allotment of the securities? Allotment of the securities means to the procedure for allotting the new shares or the debentures by the company to the investors. Offers for the securities are provided for application forms of the company. Allotment number 3 is allotment has been done when the application has been permitted. And this part and this slide shows denotes what are the procedures for the allotment of the securities. Procedure number 1, authorized share capital. The companies must have the adequate authority share capital to issue the shares or the debentures. The authorized share capital is the maximum amount of the shares that the company is authorized to issue as per the memorandum of association. Procedure number 2, issue of securities. The issue of securities must comply with the provisions of the Companies Act 2013 and the SEBI regulations. Procedure number 3, board resolution. The board of directors of the companies must pass the resolution authorizing the issues of the new shares or the debentures. The resolution must specify the number of securities to be issued, the issue price and the terms of the conditions of the issues. Procedure number 4, filling up the prospectus or the statement of lieu of the prospectus. If the company is issuing shares to the public, it must be file a prospectus with the registrar of the company, that is ROC. However, the company is issuing the shares through the private placements, it must file the statement of lieu to the prospectus. Procedure number 5, allotment within 60 days. Every company must allot the securities within 60 days from the date of receipt of the application money. If the company fails to allot the securities within 60 days, it must be refunded the application money within 15 days from the expiry of 60 days. Procedure number 6, issue of the share certificates. Finally, the company must issue the share certificates to all the allottees within the prior to the 2 months from the date of the allotments. The share certificate must be signed by the 2 directors or 1 director or either may be the company secretary. So this is the issue of the share certificates. Procedure number 7, the payment of the stamp duty. The company must pay the stamp duty on the issue of the securities as per the stamp duty law applicable in the state where the registered office of the company is to be located. Finally, the company has to be given a return of the allotments. The company must be filed a return of the allotment with ROC, that is to be register of the company within 30 days from the date of allotment. The return must contain the details of the securities allotted, the names and address of the allottees, and the amount of the receipt for them. So these are the content to be. These are the few points what we had discussed about the procedures for the allotment of the securities. And here we are going to discuss about what do you mean by the term public offer and the private placements. Every company founds to be sustained a business as these funds has to be required for the long term or the short term purposes. Sufficient for the long term needs, the company issue the shares. The issue of the shares can be done within 3 ways, which are either maybe the private placements or the public issues. So this part we are going to discuss about the term, that is overview about the public offers. The public offers refers to an invitation by the company to the public to subscribe for the securities such as shares or the debentures. This process allows the companies to raise the capital by the offering ownership stakes or the debt instruments to the investors. Public offers are regulated to protect the investors and ensure the more transparency. And what do you mean by the term? Private placements? Private placement is the cost-effective way to the raising the capital without going to the public. The private placements means any offers of the securities or invitation to subscribe securities to the selected group of the persons by the company through the issues of the private placements of the offer letters, which is satisfied by the conditions specified by the section of 42 by the Companies Act 2013. Private placement means any offer of the securities or invitation to subscribe the securities to the selected group of persons by the company through issue of the private placements offer letters and satisfy the conditions prescribed by the section under the 42 42 of this act. Thank you so much. Thank you.